Supreme Court of India Nitya Nand vs State of UP and another decided on September 4, 2024 SCC Online SC 2363 Facts of the case, September 8, 1992 at about 4:30 p.m. He and his father Satya Narain as well as his uncle Lakshmi Narain as per their daily routine, came to Ganga. All the accused persons caught hold of his father and started assaulting him with kanta and knives, and when the informant and others reached the spot, his father Satya Narain had already succumbed to the multiple injuries which he had suffered on his body. On completion of the investigation, charges under sections 148 and 302-149 IPC were framed against the accused Mana, Raju, Uchchev at Papu and Nitya Nand. Trial court on convicted the accused Shri Dev under sections 147 and 302-149 IPC and also convicted the appellant and the other sons of Shri Dev, i.e. Manalal, Raju and Uchchev at Papu under sections 148 and 302-149 IPC. High Court dismissed the appeal. Findings of the court. From the evidence tendered on behalf of the prosecution, it is clear that PW1 and PW2 are the eyewitnesses. Both PW1 and PW2 were categorical in their evidence that Shri Dev was armed with a danda, Manalal was armed with kanta and Raju and Uchchev were armed with knives. Appellant Nitya Nand was carrying a country-made pistol in his hand. Though the appellant did not assault Satya Narain, the other accused persons actively participated in the assault. Hearing the cries of Satya Narain, PW1, PW2, Kuldeep and Lakshmi Narain rushed back. When they had reached near the crime scene, appellant Nitya Nand fired a shot in the air from his country-made pistol to frighten PW1 and the others. As the appellant fired in the air, all the accused persons escaped from the crime scene. Neither PW1 nor PW2 has stated that appellant had fired at them nor he had fired at the deceased. The role attributed to the appellant was helping the other accused persons and himself flee from the scene of crime by frightening the people, including PW1 and PW2, when they were about to reach the crime scene by firing from his country-made pistol into the air. The fact that the death of Satya Narain was homicidal has been fully established by the post-mortem report as well as by the evidence of PW3, i.e. the doctor. The ocular evidence supported by the medical evidence clearly established that it was a case of murder of the deceased by the other accused persons under section 302 IPC. Appellant has been roped in by virtue of sections 148 and 149 IPC. Appellant was a part of the unlawful assembly which had the common object of eliminating Satya Narain by means of criminal force and, therefore, being a member of the unlawful assembly, he was also guilty of the offense committed in prosecution. Of the common object, i.e. the offense under section 302 IPC. Section 149 IPC creates a constructive or vicarious liability of the members of the unlawful assembly for the unlawful acts committed pursuant to the common object by any other member of that assembly. Section 149 IPC does not create a separate offense but only declares vicarious liability of all members of the unlawful assembly for acts done in common object. Trial court had rightly convicted the appellant under section 148 IPC Rev. with section 302-149 IPC and that the High Court was justified in confirming the same. Appeal is dismissed.